So that's coming at you with another video. In this video, I want to talk about the recent updates on the lawsuit. Here I am over here on the docket. If you've been following me, you know. If you're new, here's what I suggest. You just go over here and you bookmark it, click the little star, and leave it in a bookmark like I do for Allegheny lawsuit, and it covers everything about the lawsuit, okay? Now, if you come down here, that way you can find this page easier. You come down here and you see today's filings, and everybody's excited about this right here. When it was anticipated, I did a video this morning about it and told everybody that we were expecting around 8:30 that they would file all the new paperwork concerning the settlement. Now, I haven't had a chance to look at it. I looked at it on my phone, and it looks to me as if AMC's finally getting in lockstep with the judge, all right? Or the vice chancellor, however you want to say it. But she's the one run shit, all right? So, they're getting in line with her. It looks like. I haven't printed it out. I haven't looked at it yet. But I'm watching a few YouTubers, and I want to get something straight. Number one, it's not that you have one objection, okay? In my paperwork, I have 4 objections, all right? And they're not just going to take the very first objection, all right? She's talking about your objection letter. You only get 1 shot, 1 kill. That's it. You file your motion to object or your letter to object or whatever you want to call it, and you send it to the court, and that's it. And I'm going to use this letter here of the special mastery to prove what I'm telling you, all right? The special mastery also put out a letter in regards to Mr. Ocano, all right? He's the person who filed to intervene, and he was denied by Vice Chancellor Zern, and then he filed again for reconsideration of his argument, and is responding to his letter. And I want y'all to hear it, because this letter is even more important than the other letters that you see right here of the settlement updates and the notice updates. That's important. Was even more important. Let's take a look at what she said about Mr. Ocano. All right, and first off, I'd like to give kudos to this lady, whoever she is. This is a very, very smart woman. What it is it starts off with a preliminary statement that she has been appointed the special master to the case, and she understands the case as it is, and she begins to outline it. And she does that in 4 paragraphs, people. She outlines this whole case in 4 paragraphs, and I'm like, oh my God. When I tried to get it in Chat GPT, and I said, can you make it shorter? Can I make it shorter? It was 7 pages. And this lady was able to summarize the whole case in like 5 paragraphs. That was pretty fucking cool. I like that. Then you get down here, and she talks about Mr. O'Connor filed an emergency motion to intervene, and it was denied, all right? And then he filed again under Rule 59F to be reconsidered for it. And now the special master is going to rule in the case. And then she's going to send her ruling to the vice chancellor, and the vice chancellor is going to look at it, and then she's going to make her ruling based off of that. Now, she can disagree with the special master, or she can agree with the special master. In this particular case, the special master is saying that Mr. Ocano has no right for a rehearing on his motion for intervention. So he was denied his re-argument. Okay, and she states the argument right here. The proper purpose of Rule 59F, motion for re-argument, is to request the trial court to reconsider whether it overlooked an applicable legal precedent or misapprehended the law or the facts in such a way as to affect the outcome of the case, not to raise new issues. And she tells him right here, a Rule 59F motion is not a mechanism to present new arguments or to re-litigate claims already considered by the court. All right. And basically what she's saying right there is under Rule 59F, you can bring attention to particular cases that you may not have known about when you filed your original brief that would maybe sway the judge to your argument. but you cannot present a new argument because it's out of time. All right, and you cannot relitigate the same claims because the courts has already heard it, and she said no. So basically, Mr. O'Connor was stuck out here. You did not provide any new evidence, as you would say, to substantiate your original claim. So she denied it, and it was a justifiable denial, in my opinion. All right, and then she goes on to say, Mr. O'Connor's motion for a re-argument does not meet the high burden rule of 59F imposes. All right, now this is important. In his motion for re-argument, Mr. O'Connor asked the court to reconsider its March 15th letter of opinion, asserting that the court erred in denying permissive intervention and raising new arguments and facts regarding a bond request and recent events. I addressed these arguments in turn, and she begins to explain how he did not meet the burden in the beginning, and he can't meet the burden now. All right? So, what does that mean to you? If you hope to intervene in this case, you will have to meet the burden in which the settlement has upon us. Okay? There are certain rules. I told Al from Boston this. There are certain rules and reasons that AMC has said nobody's allowed to intervene anymore. All right? And if you're going to intervene, you're going to have to look at the high burden of proof and prove that they're wrong and you belong in the case. All right? But the very first step before that is going to be your letter of objection, and we're going to have to talk about that a little bit more in another video tonight. I'm going to go ahead and start printing out this paperwork. But here's what you need to know, people. You have to do this by her book. Now, we've been laughing, and you think it's funny that she's spanking AMC's ass over and over and over again. But here's Mr. O'Connor. He just got his second ass spanking, all right? That he didn't bring enough argument to begin with, and then he's trying to bring the same argument without new proof of trying to sway the judge again. So Mr. O'Connor got an ass spanking. Sorry, Mr. O'Connor. I was hoping you'd get it, but I didn't think you would. But next up is Mr. Tuttle. All right? And she gets to rule on Mr. Tuttle. Now, this is what the process is going to look like. All right? When you file your motion to intervene, the special master is going to look at our motions to intervene, and she'll make her ruling, whether we can or not. And then she'll pass that ruling on to the Vice Chancery. And I hear a lot of people saying, let me write this down too, that I just thought about it. A lot of people saying letters to the Allegheny lawyers. All right? I have to send all of that paperwork to the Allegheny lawyers. But it better get there, and they better file it, because if they don't file it, then I'm going to write the court and say that it has been 7 days, and these lawyers have not filed my motions with the special master. We're going to work around that, people. We're working on how to deal with that part. And it might take a special letter to the judge. I don't know, but we're working on it. But here's the important thing. Slow down. All right? Understand your rights. Understand what you're fighting against. Understand what you're objecting against. You're not objecting to the lawsuit. You're objecting to the settlement. All right? And that's where we can all come back together, because everybody's talking about it. We're stuck in this until the lawsuit's over with. Well, then let's come to an agreement on the settlement. And we'll talk about more about that and what I propose coming up in my next videos. Love you. Be blessed. Subscribe, notify, so you'll get the messages. See you in the next video.